prepared to explain, junior counsel initially claimed that an incorrect version of the heads had been filed, attributing the problem to short-form citations and filing a substituted version. However, opposing counsel pointed out that even the corrected version still contained two non-existent authorities and questioned whether some of the existing authorities were properly applied. Pressed by the court on whether the spurious citations were the product of artificial intelligence hallucinations, counsel considered that they appeared to be so and explained that severe time pressure, the urgency of the matter, and the withdrawal of the original junior counsel had led him to use an online tool called Legal Genius, which claimed to be trained on South African judgments and legislation, but nonetheless generated fabricated references. Fabricated citations undermine the credibility of counsel and the profession, breach the ethical duty of care owed to clients and the court, and threaten the integrity of our jurisprudence by polluting written submissions with fictitious authority. Needless to say, while AI tools can assist research, they are no substitute for independent legal reasoning and rigorous verification of resources. Lawyers who abdicate their professional responsibility to technology risk harming their clients and eroding the trust on which the legal system depends. Perhaps most striking was the case of Mavundla versus MEC, Department of Cooperative Government and Traditional Affairs, in which the court found out that only 2 of the 9 cited cases actually existed, and the judge dismissed the application with punitive costs and referred the matter to the Legal Practice Council. These cases are warning signs that the legal profession must engage proactively with the ethical, procedural, and evidentiary challenges posed by AI. Clearly, if we do not shape the future of AI in law, it will shape us and do so mercilessly. Hearteningly, as South Africa stands at the crossroads of digital transformation, the government has begun laying the groundwork for a national approach to artificial intelligence. On 5 April 2024, our Department of Communications and Digital Technologies published the Artificial Intelligence Planning Discussion Document, which is a foundational text that outlines the state's vision for integrating AI into public and private sectors and proposes the establishment of an AI expert group to work alongside government in shaping a national AI policy with a regulatory framework expected to unfold in the next 2 years. This initiative signals the intent to develop legal principles and governance instruments that ensure that AI is used ethically and responsibly. In August 2024, the National Artificial Intelligence Policy Framework was introduced as the first formal steps towards an AI Act. It emphasizes the need for inclusive, safe, and public interest-driven AI applications, while also calling for investment in AI literacy, local innovation, and improved public data systems to enhance e-government services. It will be interesting to hear how these challenges have manifested and are dealt with in other jurisdictions. Session 3 is concerned with the climate change justice. As we all know, judiciaries across the world are being called upon to adjudicate complex climate cases, often balancing environmental rights with economic development, state obligations, and intergenerational justice. This requires judges to engage in further learning on environmental matters. In a recently launched collection of essays celebrating the 10th anniversary of the South African Judicial Education Institute, its Chief Executive Officer, Dr. Mushweu, and her co-author, Mr. Wabunoha, state that, I quote, "The subject of environmental management is complex and has scientific, technological, economic, social, and equity imperatives that require continuous provision of training to judicial officers, especially with regard to the ever-evolving environmental science. Successful implementation of the law depends on a judiciary that is well equipped to adjudicate matters they preside over, close quote. Judicial education must, of course, keep pace with developments in climate change science and policy. The stakes for ecosystems, for communities, and for future generations could not be higher. Investing in continuous, contextually relevant judicial training is no longer optional, it's an imperative. But no court can address this challenge in isolation. Climate justice demands transnational legal dialogue, the sharing of jurisprudence, and perhaps even joint frameworks for accountability and enforcement. In session 3, our colleagues from France, Australia, Indonesia, and Mozambique will no doubt provide us with helpful pointers for the increasing volume of climate-related litigation and the need for coherent judicial collaboration across borders. This session, therefore, is essential, not as a theoretical exercise, but as a space to equip our courts to act, to innovate, and to reinforce one another. As the climate crisis deepens, so must our resolve as jurists to deliver climate justice fairly, boldly, and collaboratively. The last 2 years have marked a turning point in the evolution of global climate jurisprudence, and 3 landmark advisory opinions delivered by the world's most respected international courts have laid a new legal foundation for climate accountability and state obligations, and I'm sure we'll hear all about those when we get to that session. The last session is concerned with combating cybercrime. In executing its mandate, the South African judicial system is reliant on digital infrastructure. For example, the court online platform and emails for important reasons such as case management, efficient communication, and enhanced public access to legal services. The digitization of court operations through the integration of digital technologies has improved procedural efficiency and arguably access to courts. This transformation was notably accelerated by the COVID-19 pandemic, which necessitated the adoption of virtual hearings and other remote legal processes. However, this digital transformation encompasses significant risks in relation to cybersecurity, for example, ransomware attacks, unauthorized access to sensitive judicial information, and data breaches. Fortunately, South Africa has a robust legal framework governing cybersecurity and aimed at combating cybercrime. Legislation such as the Cybercrimes Act, the Protection of Personal Information Act, and Electronic Communications and Transactions Act. As an institution, the Office of the Chief Justice is responsible for the administration of superior courts and is a vital role player in overseeing the digital transformation of judicial processes. The Department of Justice and Constitutional Development also have a responsibility for broader justice sector IT systems and must ensure compliance with cybersecurity legislation. This equips the judiciary with the necessary tools to detect, investigate, and protect our institutions. Although the shift towards digital systems have had significant advantages, it has also introduced new layers of complexity and potential security gaps that require attentive oversight. Given the inherently sensitive nature of the judiciary's infrastructure, it is imperative to implement robust cybersecurity strategies to safeguard the judiciary's electronic and cyber infrastructure from malicious threats. As the judiciary becomes digitized, its vulnerability to cyber attacks grows. In light of this, there is a need to ensure a high standard of cybersecurity, not only in relation to the protection of data, but in preserving the integrity of the justice system and maintaining public confidence in its operations. Therefore, judicial bodies must adopt a proactive and strategic approach to mitigating risks by implementing rigorous information and data protection measures. Another common challenge is the lack of, or rather limited adequate technological infrastructure within the justice systems, including the availability of computer equipment, reliable and fast internet access, and secure data storage systems. Without a strong electronic and cyber infrastructure, achieving successful implementation of electronic processes can be challenging, and it will be interesting to hear how other jurisdictions are coping with these challenges. The alarming growth rate of cybersecurity threats, which also affect judicial institutions, makes clear that there's an urgent need for a comprehensive and proactive approach to digital security and implementation of robust technical safeguards and organizational practices that collectively strengthen the justice system's digital infrastructure. The measures which are recommended to secure remote connections and protect sensitive data during transmission, such as virtual private networks and multi-factor authentication, touted as significantly reducing the risk of unauthorized access, align with South Africa's broader legal obligations under the Protection of Personal Information Act and the other legislation in that space. We look forward to the exchange of experiences and solutions in this area as well. As I conclude, please allow me to extend in advance our gratitude to the distinguished facilitators of the summit sessions. Their role guiding our discussions with expertise, patience, and insightful direction is the engine of our dialogue. The complex and critical topics on our agenda demand not only knowledge but also skillful leadership to navigate diverse perspectives, and we are confident that their stewardship will ensure discussions that are productive and enlightening and pave the way for meaningful outcomes. Our appreciation extends to the esteemed panel members who have dedicated significant time and intellectual rigor to prepare for these discussions. We have no doubt that their contributions on the various topics will broaden our understanding and add substantial depth to the collective wisdom assembled here in South Africa today. We also thank every nation represented here. The diverse perspectives from every corner of the world will certainly enrich our discussions immeasurably and remind us that our collective strength lies in our unity and our willingness to listen, learn, and collaborate towards a common future. The arc of the moral universe is long, but it bends towards justice only when we possess the courage to bend it. I trust that we will use this summit to reaffirm our core vows to judicial independence as a shield against coercion, transparency as the antidote for distrust, and unwavering accountability to the people we serve. We have the power to shape the next chapter of global jurisprudence. Let us write one that future generations will look upon with gratitude and pride, a chapter defined by courage, innovation, and an unshakable faith in the enduring power of justice. Thank you.
Thank you very much, Chief Justice. And could I request another round of applause, please, for the CJ? What's going to happen now is I just need to make one correction to, I think, in the protocol list, we should have acknowledged as head of the delegation of Algeria, Justice Abbas Amar. Please accept our apologies for that. And then you would have worked out already the channels for interpretation. Number 1 is for English, number 2 is for French, number 3 is for Portuguese, number 4 is for Turkish, number 5 is Arabia, number 6 is Korean. Thank you very much. And then before I direct the photo shoot process, I just need to introduce the session facilitators because there will be no one to introduce them. I'll start with the session facilitator for the first session after this, the photo shoot. That is Justice Leona Theron.